This is Chapter 3, Regulatory Issues. In this chapter, we'll be talking about many things related to employment laws, the EEO, Employment Opportunity Commission, and several other things as well, including affirmative action and legislation. This chapter represents the third component of the HR challenge on primary HR activities, the regulatory issues, the laws that affect the way HR is conducted. In this chapter, we're talking a lot about equal employment opportunity, and by that I mean laws, regulations, and processes related to the fair treatment of employees. When we think about how EEO laws, equal employment opportunity laws, have been created, we usually see, or historically, we've seen Congress being lobbied by individuals to address societal problems. Then laws get passed to address those problems. Again, discrimination in the workplace being a good example. Then we have to, in order to make sure that the law is enforced, there's generally an enforcement agency designated to oversee compliance with that law. And then the agency develops guidelines and communications to communicate to businesses so they know when they're in compliance with that law. Then employers comply with the law. And whenever there's an issue that comes up, well, we'll see examples of courts hearing cases of the law being violated. So think of these laws as being a process of Congress being lobbied by groups experiencing discrimination or seeing discrimination, passing a law that comes with an agency to enforce the law and pass guidelines around the law. And then employers complying with the law, and courts hearing cases when employers may not be complying with the law. Two important regulatory agencies we'll be talking about are the Equal Employment Opportunity Commission and the Office of Federal Contract Compliance Programs. We'll talk in this chapter a great deal about protected classifications, and by that I mean demographic characteristics that can't be used in employment decisions. Decisions like hiring, firing, training, promoting. And those characteristics are things like race, sex, religion, color, national origin, age, disability, veteran status, pregnancy, and genetic information. Some laws we'll talk about specify which group is protected within a classification, but others do not. An important topic we'll also be talking about are bona fide occupational qualifications. So when we think about the protected classifications that can legally, think about the discrimination that's trying to be prevented with different laws, we can think about the protected classifications that are used to make employment decisions. If, for example, an organization wanted to, for whatever reason, hire someone and wanted to make sure they were hiring, say, a male for a male role in a movie, they could discriminate, and by that I mean deliberately only offer the position to men, and argue that being a male for that movie is a bona fide occupational qualification. It's a business necessity that they have a male in that particular position. So bona fide occupational qualifications refer to times when businesses can discriminate in terms of who they hire on account of the fact that they would argue that it's a business necessity that we hire this particular type of individual. So we'll talk about examples of, say, a religious school that would only hire people of that faith to work there, or other examples when sex, religion, and national origin can be used to hire individuals. But it's important to note that race and color, skin color, can never be used as bona fide occupational qualifications. We also talk about disparate treatment, this concept of treating individuals differently in employment situations because of membership in the protected classification. And by that I mean, if an individual is a member of a protected class, they're an older employee, male or female, they're of a minority group, they have a disability. So if they're individuals, a member of the protected class, a class of individuals that have been identified by legislation that they're protected from discrimination, and if they're qualified for and applied for the job or some kind of other employment opportunity, and then they're rejected from that job, and then someone else got the job or the employer continued to seek applicants. In that situation, when you apply for the job or you were terminated from a job or whatever happened, if the employer didn't hire the individual and who was qualified for that position and then continued to seek other applicants or something else happened, then that's a prima facie case of disparate treatment. Someone being treated differently due to their protected status. Sometimes, though, it's complicated by the fact that someone may not get hired for several reasons. I may not hire an individual both because she was a woman applicant and I discriminated against women, and also she didn't interview very well. So, when those examples come up, an employer may argue there is a mixed motive situation where there was both a legitimate reason and an illegitimate reason for the decision that gets made. Mixed motive cases occur when there's both an illegitimate reason, for example, not hiring someone based on their protected class, as well as a legitimate reason, not hiring someone for poor performance in an interview, for not hiring someone. So disparate treatment refers to acting against someone because of their status. Disparate impact is different. Disparate impact refers to when we discriminate against someone not because of their particular, not deliberately, but we put policies in place that while they seem neutral, actually end up discriminating against individuals. So when we talk about disparate impact, we're talking about examples of cases in which we put a seemingly objective rule in place that has the impact of discriminating against certain individuals. For example, if we had a position for a manager position and we only took college graduates, and perhaps in a particular area more men than women went to college, or a particular time in our history more men than women, so we only wound up hiring men. The business could say, well, we weren't deliberately hiring only men, but only men had college degrees. But a claimant could make the case that even though the rule in place does not discriminate, the impact of the rule does. And so even though the rule in place doesn't seem to be intentionally discriminating, the impact of the rule is to discriminate against protected groups. When we're evaluating disparate impact, a rule of thumb is a 4/5 rule. And so, for example, if we're seeing if a group is being discriminated against in terms of hiring, we can look at the hiring rates of both the majority group and the minority group and see if the hiring rate for the minority group is at least 4/5 the hiring rate for the majority group. That's a complicated rule, so let me give you a specific example. For example, let's say we worked at a company where we had both Asian and white applicants for a particular job. There were 120 Asian applicants for the job, and out of that 120 people, we hired 7. If we hire 7 people out of 120 people, that gives us a selection ratio of people we hired of 5.8%. Of the white applicants, there are 355 people who applied, and 31 of them were hired. So we hired more white applicants than Asian applicants, but then again, we also had more white applicants than we had Asian applicants. So we hired 31 out of 355 white applicants. 31 out of 355 is 8.7%. So we hired a higher percentage of the white applicants than we hired of the Asian applicants. But that's not by itself the issue. The issue is 5/8 80% of 8.7%. The 4/5 rule says we may be in violation of disparate impact if the 5/8 of the selection ratio for the minority group is less than 80% of the selection ratio for the majority group. By dividing the selection ratio of the minority group, 5.8, by the selection ratio of the majority group, 8.7, we get a number of 67%. So actually 5.8 is 2/3 of 8.7%, not 80% of 8.7%, which is the desired 4/5 rate. So this does suggest that a policy we have in place may be discriminating against Asian applicants. And if we worked for a company in which we saw the selection ratio for minority group was less than 4/5 of the selection ratio for the majority group, we might tell our employer, might tell them they may be subject to a disparate impact case. If there is a disparate impact case, some of the defenses that a company could offer are that there is a practice that is job related. Perhaps we have a test of language ability or something that winds up discriminating against a group. But if we can demonstrate that the test we give is still job related, that can be a defense. If we could demonstrate that the practice is a business necessity, that yes, we have a test of strength for this particular job, but you need to be able to lift this much in order to do this job, then we could argue that the test is a business necessity. Or we could show we have a seniority system. And so yes, there is discrimination, but it's due to the fact that we have a seniority system in place, which leads to one group being promoted at a greater rate than another group. This leads us to the issue, or a separate issue, of harassment. When we talk about harassment, we're talking about subjecting employees to unwanted and unwelcome treatment because of membership in a protected class. And so if someone's a member of a class, ethnic minority, or has a disability or is male or female, and because of that, they're being mistreated or being given unwanted or unwelcome treatment. That can create what's called a hostile environment, or sometimes called a hostile work environment. The book goes through several examples of both the company and manager responsibilities for reducing harassment in the workplace. Please take a moment and read over these examples. If an employee raises a question about harassment to their supervisor, it's very important that the supervisor or the management does not retaliate against that employee. Retaliation refers to taking adverse or negative action against an employee who has filed a discrimination complaint. Sometimes if someone raises an issue about sexual harassment or racial harassment, then their supervisor may take a negative attitude towards that kind of complaint or that kind of issue being brought forth, and might demote someone or give them less responsibilities as retaliation. That practice can be extremely negative for the organization, and in HR, individuals usually try to steer organizations away from making those kinds of retaliations. There's several laws related to the workplace and to HR, and some of the most important ones are like the Equal Pay Act of 1963, the Title VII of the Civil Rights Act of 1964. That's where the prohibitions against race, color, religion, sex, and national origin discrimination originate from. The Executive Order 11246, which also applied the similar protections to anyone contracting with the federal government. The ADEA Act and Age Discrimination and Employment Act prohibits discrimination against individuals who are over 40 when you're considered older by the federal government. The Pregnancy Discrimination Act requires that women must be given the opportunity to do their work like anyone else with a similar limited or temporary medical condition. And the ADA and the ADAA, the ADAA of 2008, both prohibit discrimination against qualified individuals with a disability who can do the job with or without reasonable accommodation. There are other laws too to consider, but these are probably the most central ones that we'll talk about in this chapter. So again, the Equal Pay Act of 1963 was an amendment to the Fair Labor Standards Act, and illustrates mandates that gender can't be a factor in paying employees, especially if males and females are doing jobs that's substantially equal in terms of skill, effort, responsibility, and working conditions. Differences are allowed for merit, seniority, quality, and quantity of production and other non-gender related factors. But the employer must prove a stated reason for pay differences. Must prove stated reason for pay differences is allowable in affirmative defense. The Civil Rights Act of 1964 again is where we get the prohibition against discrimination based on race, color, religion, sex, and national origin. It applies to all employers with 15 or more employees. Again, it was later expanded to cover not just the federal government, but also anyone contracting with the federal government. Some examples of practices that are prohibited is not hiring someone because of their skin color, requiring someone to work on a Saturday if their religion prohibits that, giving males different benefits that females receive, giving preferential treatment to individuals born in the United States. All of these are practices prohibited by the Civil Rights Act of 1964. Gender discrimination refers to discrimination against individuals based on their gender. One important distinction we make when we talk about gender discrimination is in terms of sexual harassment. I feel like there's maybe more, there's still examples of quid pro quo harassment where individuals are put in a situation in which they're asked to engage in sexual acts. In exchange for that, they'll be given a chance to promote. So a quid pro quo harassment is an example when someone who offers an employee the opportunity to promote if they'll engage in sexual activities that they probably would not otherwise engage in. Well, I feel like that may be something that doesn't happen as often as it used to. There are still several high-profile examples of quid pro quo harassment today. What I feel is more common today is hostile environment harassment. And that's harassment when people are not necessarily the direct subject of the harassment, but they're made to feel uncomfortable by things being discussed at work or topics being discussed at work that make them feel uncomfortable based on their gender. So hostile environment harassment refers to when you're not necessarily the target of harassment, but you feel uncomfortable based on the sexual nature of conversation or activities or other things going on in the workplace that aren't appropriate to the workplace. The Pregnancy Discrimination Act of 1978 prohibits discrimination because of pregnancy, childbirth, or related medical conditions. And again, employers must treat pregnancy the same as any other medical related condition or temporary disability. Also, as part of the Pregnancy Discrimination Act was the requirement that company health plans can't exclude pregnancy in their health plans. The Civil Rights Act of 1991 addressed the burden of proof in disparate impact cases and prohibits race norming of tests. Race norming refers to if I had a test I really like to use for hiring employees, but I found the test discriminated against minority groups. Race norming is a practice of adjusting scores so that someone from the minority group who's being discriminated against by the test would receive extra points by virtue of their being in the minority group. And then I could still use the test because I'm balancing the scores out by race norming the scores. That practice was prohibited by the Civil Rights Act of 1991. It also eliminated the use of mixed motive defense in disparate treatment cases. And we talked about mixed motive before, where if I can say that yes, I was being discriminated or being racist in not hiring someone from a minority group, but I also had good reasons for not hiring that person. Well, if a person can establish that I was racist and that played a part in my decision, then just because there may be good reasons not to have hired the person as well isn't a defense based on the Civil Rights Act of 1991. The ADA, again, is a law that prohibits discrimination against individuals 40 or older. Again, it applies to employers with 20 or more employees. And again, that means that after 40 years old, if you're terminated and replaced by someone younger than you, and that you can demonstrate it's because of your age and not because of other factors, then you can sue for age discrimination. Americans with Disability Act, it prohibits employers from using disability for discriminating against qualified individuals. So if a candidate can do the work and is qualified for the work, and just because they have a disability, I can't use that disability in making the decision. It requires that employers provide reasonable accommodations. So if I'm hiring someone and for a position and they perhaps they're disabled and require the use of a wheelchair, if they need some reasonable accommodations in terms of say larger workspace or things I can accommodate, then if it's a reasonable accommodation, then I'm required to make that accommodation for a qualified employee. On the other hand, if I can argue that it'd be undue hardship for me to make those adjustments or those accommodations, then that would be a defense I could engage in. All of these, there's several important terms to talk about here. So the ADA defines disability as a physical or mental impairment that substantially limits one or more of life's major activities. A reasonable accommodation is making modifications to work environments so that a person otherwise qualified can perform essential functions. And the essential functions are the job tasks, duties, or responsibilities that must be done by a person in a job. So again, if there's a task done that's not essential for that particular job, then maybe that's not something that particular person wouldn't need to do. But if there is, for an essential function that I can make a reasonable accommodation for, the law would require that. And if I felt that it would be too expensive for the company to make those accommodations, then I need to argue that it would be an undue hardship to make those accommodations. The ADAA of 2008 made some additional changes, expanded the definition of major life activities, revised substantially limits as defined by EEOC. Other things that were addressed as well. Again, for examples of reasonable accommodation, providing a sign language interpreter for an interview with someone who's deaf, changing the signs of a store display so that a sales associate in a wheelchair can have access to his job, reallocating a non-essential task, such as occasionally taking boxes to a storage room for an employee with a back problem to another employee, and replacing it with a different task. And so if there's a side task that's not essential to my job, that can be delegated to a different employee, then I could take on a task from that employee that's maybe not essential to their position. And allowing employees to work from home if doing so would not create undue hardship on the employer. One more recent law I wanted to mention quickly was the Genetic Information Non-Discrimination Act of 2008. It prohibits the use of genetic information for making employment decisions, and that includes genetic tests and information about from family medical histories. The book also gets into talking about how social media can result in employment discrimination, and that's very important that HR consider that, as again, social media has become such a common thing today, and it's not uncommon for employers to use Facebook and Google searches to look at employees who are applying to different positions. So related to that, it's important to think about how that could play out. For example, if a supervisor views pictures and other information posted online about applicants during the employee recruitment, it's possible they could learn things about race, gender, and disability. And if they learn those things, and that led to them discriminating against that person, that could lead the company to be liable to be sued by that particular individual. It's possible the employee posts information about them on their website too, or may post personal information, or they may post information about their beliefs or their religion on their websites. And so again, if the employee posts that information and that they don't get the job and they can demonstrate it's because the supervisor found out about that information and played a role in their decision, they can make the company liable, as well as just lead to an unethical decision making in terms of hiring. Again, we talked previously about globalization. It's important to remember that the EEO laws must be observed by U.S. companies doing work in other countries as well, unless it'd be violating the law of that country to follow the rules of the EEO. Non-U.S. companies doing business in the U.S. must also abide by EEO laws, absent some kind of international agreement or treaty in effect that doesn't require this practice. So again, even if you're doing work outside the United States, the equal employment opportunity laws still apply unless there's another law that precedes it. And other countries who have organizations from other countries doing business in the United States, likewise, have the same restrictions put on them. If you ever find yourself the victim of discrimination based on your race, religion, skin color, national origin, or gender, you have several steps available to you. You can contact the EEOC office and you can speak to someone there. They review the evidence and decide if they want to investigate and attempt to settle with the employer. If they can't settle or work it out with the employer, they may take the case to court. And then you have 90 days to file a lawsuit if the EEOC decides not to pursue. So the EEOC gets contacted by people all the time who have examples of discrimination against our employer. If the EEOC takes the case, then they'll sue the employer on your behalf and they'll take the case to court. If they decide not to, then they may refer you to someone else or just say that they won't file suit, but they think you do have a good case. And in that case, you'd have 90 days to file a lawsuit if the EEOC decides not to pursue themselves. Increasingly, we're seeing that cases don't get settled in court, and usually organizations prefer to seek out an alternative dispute resolution, ADR. So policies of instead of going to court, using a mediator or an arbitrator to try and work out differences between the employer and employee. Again, this is a bit out of sequence, I apologize, but don't forget, Executive Order 11246 expanded the Civil Rights Act to include not just the federal government, but also anyone doing business with the federal government, and also required affirmative action programs for federal contractors. Affirmative action is an important topic to mention, again, because it came out of the Executive Order 11246. Affirmative action is often reported as being, or thought of as being, rules that require hiring people from minority groups over more qualified people from other groups. And that really isn't the intention or goal of affirmative action. Affirmative action requires just trying to expand the number of people who apply to jobs, and if two people are equal, had the exact same qualification, then perhaps you give the opportunity to the minority individual. But it isn't the case that affirmative action requires passing over people, more qualified people, to promote less qualified people from minority groups. So affirmative action is a complicated process that requires conducting utilization and availability analyses, finding goals and timetables, and developing and implementing an action plan. Today, there's increasing concern from different groups about reverse discrimination, where people feel like or experience the discrimination in which members of the protected group receive preference in employment decisions, resulting in discrimination against the non-protected group. The Immigration and Reform and Control Act of 1996 was another rule that also is important for HR individuals in HR to have some familiarity with. This is where this is where we organizations have the requirement they must verify that all employees hired have legal right to work in the United States. Again, that's an important distinction to make, right? If you had an employer who asked individuals if they were born in the United States, that'd be a very dangerous question, because then if you don't hire that individual, you may be discriminating against them based on national origin, which again is prohibited by the Civil Rights Act. However, asking if someone is legally able to work in the United States is perfectly legal, and that's something that employers should or often do. The Family Medical Leave Act, FMLA, is an important law to consider as well. It requires that employers of 50 more employees must grant 12 weeks of unpaid leave for an employee's illness, if they have a child born, if they adopt, if they take foster care of a child, or if they have a sick member of the immediate family. So FMLA gives employees 12 weeks of unpaid leave. Again, they don't have to be compensated for that time they're away, but it gives employees a chance to either deal with their own illness or a family member's illness, or within a new family member, a new child, or an adopted child or a foster care child. Other rules focus on rules related to veterans, like the Vietnam Era Veterans Readjustment Assistance Act, which require protection for Vietnam era veterans, special disabled veterans, and other veterans who serve active duty during war or recognized military campaign. The employer to which the act applies must list most jobs with local state employment offices. Likewise, the Uniform Services Employment and Reemployment Act is an act similar for the military services or military members, which ensures civilians called for active duty can keep jobs when they return from assignments. And so if you're called into duty, your job will be there for you when you return. Another important concept to consider is that we tend to think of employees as working at will. So what that means is the employers have the right to terminate, hire, or transfer employees at any time, as long as doing so is not illegal. And likewise, employees have the right to quit their jobs at any time or for any reason. And so when we think about employment at will, that concept refers to the fact that your employer can terminate you at any time for legal reasons, and you also can quit your job at any time. So the contract between you and your employer lasts as long as you both want it to. Wrongful discharge, though, of course, is when you're fired for reasons that we either